Okay, we're going to try to have other people catch up to us because we do have a limited amount of time. So anyway, my name is Marty Graff and I'm the...
I know you.
You know me. I'm the Chief Executive Officer of Community Living Tillsonburg. And today's event has three sponsors. Community Living Tillsonburg is one of them. And the Community Advocates Tillsonburg Group is one of the sponsors, as well as the People First Tillsonburg Group. Now, we're hoping that this topic of supported decision making will become a kind of annual event. Now, you'll be hearing from, and I'll introduce our main speaker, Brendon, Pooran, shortly. But tonight, at tonight's session, we have a special guest. And that special guest is a pioneer in the movement of supported decision making. Our friend here, Barb Kassan. If you recall, we had a strike here in 2007. And she actually wrote a letter to me about her concerns. So she wrote a letter to me saying, I'm just not liking this happening at my house. Right, Barb? You wrote this letter to me.
I know you did.
Yep, you did it. And then there's this guy, Orville Endicott. And Orville Endicott is was the legal counsel for Community Living Ontario. And he was asking around the province, would anybody be willing to take the challenge up about the issue of picketing at people's homes? And because Barb had said, I don't like this, in her letter to me, we asked Barb, are you willing to take it to the Human Rights Tribunal? That's when she got to meet another lawyer, Kate Stevenson.
Yep.
Hey.
Kate is my lawyer. Yes, she is.
She was your lawyer. Anyway, in this particular ruling, there was an interim ruling made. An interim decision. Does Barb have the right as an individual to put the claim in to the Human Rights Tribunal? Because they were questioning her capability and capacity. But Barb had a friend. And who was your friend? Lynn? Lynn. And Lynn was willing to help you put your application in, right?
Yes, sir.
Yep. The Human Rights Tribunal cited the UN Charter of Rights for People with Disabilities.
Convention on Rights of Persons with Disabilities.
Yeah. Okay. And said, since that just has been passed, we believe that Barb, with supports, does have the capability to put forward her complaint. And so you got to bring forward your complaint, right, Barb? How many lawyers were you up against? There was, I think I heard about 6 or 7 lawyers against Barb and her lawyers. Now a decision was made, a final decision, and that's this decision that said, unfortunately, the union option does have the right to picket at people's homes. The Ministry of Labor says it's a workplace, all those kinds of things. We still think it should be first and foremost your home, Barb, and not have to have picketing. But that was the ruling. They said they could picket at people's homes. There's an interesting statement, though, that says, this conclusion does not mean that the claimants have no legal recourse to deal with their concerns about picketing, and they may be able to put forward their concerns about the effect on them in other types of legal proceedings, or perhaps make a claim under the code against the service providers, us, or the government. Claims made here against the unions, however, are not covered by any of the social areas in the code. So Barb went all the way up to the Human Rights Tribunal. Unfortunately, we didn't get a ruling in your favor, Barb. But what you see there in front of Barb is an award she won. The first Orville Endicott Social Justice Award. So that was presented to her and Lynn in September, I think it was. Right, Barb?
Yep.
And it was also at a time when Orville Endicott retired. So Barb, do you have anything else you would like to say at this time about winning the award and what your experience was like?
Nope.
Nope. But I heard one thing that you told everybody in that hearing. Something about not at BK's place or something? Did you say that to everybody, all the lawyers? No picketing at BK's.
I can't remember that body.
Yeah, that's what I heard you say to them. You didn't want picketing at your home. Anyway, I think we should all give Barb for having the courage to stand up and also receiving that first Orville Endicott Social Justice Award. Anyway, and we appreciate you being here, Barb, because you are a pioneer in this supported decision-making concept. So, on that note, we'd like to just introduce Brendon Pooran. He is a lawyer with Pooran Law, based out of Toronto. Its main focus is disability law. He did experience some early training in his younger days under Orville Endicott. And he is also a past president of the York South Community Living Organization as well, and a father of 3. And he has been focused, he's been taking up, if you will, the torch that Orville Endicott has led over the years in terms of supported decision-making. Over the years, we've seen that people's rights have not been respected, and we're trying to keep on moving the yardsticks that people's rights should be respected and that their decisions should be respected as well. So here to carry on the conversation, we're hoping this becomes a kind of annual event, that every year we get an update on the progress that we're making on this concept of supported decision-making. So, turning it over to our friend and colleague, Brendon Pooran.
Thanks very much, Marty, and it's a pleasure to be here tonight to speak to you about supported decision-making. As Marty said, we've got a small law firm based in Toronto, and a lot of the time that we spend on trying to influence law reform really does focus in on the area of our laws that affect legal decision-making here in Ontario. So we're definitely proponents of supported decision-making, and what I'd like to do here tonight is start off by providing you with an overview of what the legal system looks like here in Ontario with respect to legal decision-making, capacity issues, identify the issues and the problems with our legislative framework, and then have a little bit of a conversation around what supported decision-making is and what we envision it looking like. Always interested to hear why you've chosen to come out tonight. It sort of provides me with a little bit of context, and it'll help me to guide the conversation a little bit. So if anybody wants to sort of share with us, what you're looking to get at tonight's session, please go ahead and do so.
Go ahead, Michelle. I'm a parent of 4 children. 3 of them have Down syndrome. One of them also has autism, very degree of abilities and gifts, and just want to be knowledgeable about this area for sure, and moving forward and planning for the future for them.
Sure. Okay. Thank you.
We're also parents and a couple boys with autism, and they're becoming adults, so we just need to know.
Need to know where
We need to know.
how things work. Sure. Okay. Anybody else?
I have a son that's in hospital for about a year and a half, and I'm looking for a home for him, and I'm trying to decide whether I should get a power of attorney or should I get a legal guardian or
Sure.
where the
Sure.
capacity thing comes. And
Okay, good. Okay, great, well, thank you for sharing. So that informs me, that tells me that I think there's an appetite to learn not only about sort of the laws that exist now and what, individual rights are and what family rights are, but also where we'd like to see the law go. Do you have a comment?
Yeah. So one of the reasons I'm here is I was helping a young fellow who his mother was acting as trustee. He's now 19 years old, wanted mom off of it. Mom saying absolutely no way. Decided, okay, I'll go, and the agency that he's supported by said, we'll pay for capacity assessment, get this done. He didn't pass the capacity. Look, they said you don't have the capacity to make these financial decisions. We all thought that he did. Now, the second part, because he wants to be able to see his father on a regular basis under his terms, stuff like that, without the mother's influence. And it's around all of this, how does he make these sorts of decisions on his own
Without her interference? Okay, thank you. Okay, so we can definitely address that. All right, so let's start off with a bit of an overview around what the law currently looks like. The first point that I sort of want to make is that the test for capacity differs depending on what type of decision has to be made. So there's no sort of global finding of incapacity or incompetency or whatever other terms you may come across. The test actually differs. That being said, there's this common theme throughout most of the tests that speak to the person's ability to understand and appreciate. What we mean there is, does the person have the ability to understand the information relevant to making a decision? And secondly, are they able to appreciate the foreseeable consequences of their decision or lack thereof? So if we're talking about a specific medical condition, let's say, do they understand what the medical condition is? Do they understand what the treatment or the medications for that medical treatment can do, generally speaking, okay? The second part of the test would be applying that information to themselves. So do they appreciate the consequences of saying, yes, I would like the medication, or no, I would not like the medication? Can they evaluate sort of the risks and benefits associated with that medication? So in order to be deemed capable, individuals must satisfy both parts of the test, the understanding and the appreciation. That being said, there are nuances when the test is applied. And so the test does differ depending on, again, what sort of subject area or decision has to be made. So there's a test for determining whether or not somebody's able to manage property, for determining whether or not somebody's able to manage personal care or consent to personal care decisions. And personal care decisions include healthcare, hygiene, nutrition, safety, shelter, and clothing. There's a different test to determine whether or not somebody can give power of attorney for property or power of attorney for personal care. Can somebody make a will? Can somebody sign a contract? These are all sort of different tests. So the point here is that just because an individual may be deemed incapable, let's say, of managing their finances, it doesn't mean that they are automatically also incapable of deciding where they want to live. Okay, the tests and the evaluations and the assessments are very, very specific. Okay? In Ontario, there's sort of two broad areas of decision making. The one deals with a person's property, and the other deals with an individual's personal care. So property being your finances, your real property, etc. And personal care, as I just mentioned, covering healthcare, hygiene, nutrition, safety, shelter, and clothing. Regardless of whether or not we're talking about property or personal care, the law says that there's this presumption of capacity. So all of us, regardless of ability, are presumed to be capable. Okay? That's the starting point. Unless there's evidence that raises the question of capacity and a decision has to be made. Okay, so we're all presumed to be capable. That's the starting point. And again, this is regardless of ability. Okay, if there's some sort of concern around that presumption and a decision has to be made, that's when we start to get into what consideration as to whether or not capacity needs to be assessed. So when capacity needs to be assessed, we say, okay, well, who assesses capacity? And remember, I said a few minutes ago, there isn't sort of this global finding. A lot of people are sort of under the misconception that a doctor can write a letter and automatically, declare a person, label a person incapable or incompetent. That's simply not true. So in terms of who assesses capacity, it depends on what type of capacity and what type of decision needs to be made. I've got a couple of examples up here. So let's say somebody wants to grant power of attorney or wants to make a will. It's typically the lawyer that's assessing the person's capacity. So anybody that walks into our office that wants to make a will, we've got to assess whether or not they meet that level of understanding and appreciation. If we're talking about healthcare treatments, okay, it's usually the healthcare practitioner, okay, the medical practitioner that is undergoing some form of assessment to determine whether or not the level of understanding and appreciating is there. If the level is there, then they should be taking direction from the individual. If not, then they would seek consent from somebody else, and we'll get into that in a few minutes. Okay? In terms of formal capacity assessments are carried out by registered capacity assessors. But very rarely should a person be subject to a formal capacity assessment. Okay, typically we see them happening if it's required by a power of attorney document, or if an application for guardianship is being made. If an application for guardianship is being made, then a formal capacity assessment or multiple capacity assessments accompany that application. And we'll get into a discussion about guardianship, but the point here is that capacity assessments are very, very long, drawn out, costly processes that really nobody should have to go through. Okay, it's not something that is necessarily encouraged. Although we hear of situations where like the one we just heard about a few minutes ago, where there's an individual that's looking to be able to make decisions on his own without the interference of another family member. Unfortunately, sometimes the only way to sort of pursue that is to request a capacity assessment. Although it is a bit backwards, because the law says that the starting point is always the presumption of capacity. So I'm presumed to be capable unless I get assessed or evaluated and there's this label attached to me. So a person shouldn't really have to go through a capacity assessment in order to be deemed capable. It should be the other way around. Okay?
What if it was more day-to-day, like, what if it was just like opening a bank account? I think I can honestly say when I helped my son open a bank account and he signed his name and he doesn't really have a formal signature, although he does now.
Yeah.
He didn't really understand what he was signing to open that bank account. But the more banking he does, the more understanding he builds.
Sure.
However, where he was making that signature, a banker could have said, I don't know that you're understanding what you're signing. Is that correct?
Yeah, I mean, it is within the bank's authority to assess whether or not somebody is capable of signing a document when they're opening a bank account. I mean, really in this day and age, people shouldn't face any difficulty in terms of opening up a simple bank account. We'll find that informally, the financial institutions are kind of respecting parents or supporters in terms of helping. When it comes into more sort of complex financial instruments like RDSPs, or if we ever get into talking about mortgages or loans and that sort of thing, where the foreseeable consequences of signing that are a lot more considerable
Okay.
than the financial
So he has
institution.
signed his RDSP, so can we go there, or will you go there at some point this evening?
Yeah, I mean, I'll definitely go there. I mean, the point here is that if the institution, if the third party has accepted the signature and believes, remember, the starting point is always the presumption of
Yeah.
capacity. Right?
Okay.
So if the third party is accepting the signature, they're inherently accepting the fact that he is able to understand and appreciate, and you sort of move forward from
Okay.
that point. Yeah.
Thank you.
I think I saw another hand. Maybe not. Marty?
But again, I think with that situation, I believe you're also saying that he's being supportive when he's going to the bank. With your support?
Not solely,
Not solely. But
but you're right, he
But
doesn't have to
at
go.
the starting point,
At the starting point.
he was getting support. So again, that's that notion that the individual with the supports gets accepted.
That's right, and is able to make a decision, right? Like,
Yeah,
we get into a conversation a little bit later about all of us requiring support. We just require different levels of support, right? And so with that support and with any kind of accommodation that was presented or by the bank, your son was able to get there, and he was able to make a decision and move forward and open up his bank account. So that's really the thrust of what we are striving for and what we want to talk about in the second part of the presentation.
okay.
In terms of the capacity to consent to personal care, you can see that the test applied here in terms of the requirements focus squarely on the ability to understand and appreciate. So again, can the person understand the information? Can they apply the information to themselves? Without presenting you with kind of an exhaustive list of questions that individuals may ask to assess this, I've got 3 here. Can the person understand the condition for which the treatment's being proposed? Can they understand the information relevant to the treatment itself and sort of weigh the risks and benefits of the treatment? So those are some considerations that would be taken into account with determining whether or not someone could consent specifically to healthcare. On the property side of things, you can see that we have the understand and appreciate components there, but when you apply the test, it kind of sets a bit of a higher bar. Is the person aware of the nature of his or her assets, liabilities, incomes, expenses, and responsibilities towards dependents? And the rest of the questions kind of build on that. And so, for some people, it is quite difficult to sort of, or understand the concept of money and calculations and budgeting and that sort of thing without support, right? So if we're saying, a person must understand all of this without support, there are going to be several individuals, many individuals in our community that simply wouldn't meet the test, and therefore they'll be labeled again as being deemed incapable of managing property. Okay. So if an individual, step 1 is always the determination as to whether or not, step 1 is always the presumption of capacity. If someone questions that, step 2 is saying, okay, does this person have capacity according to our legislation? Would they be deemed capable? If the answer is yes, the person is able to make a decision on their own. If the answer is no, then the question is, well, who can make a decision for them? Unfortunately, our legislation doesn't recognize supporters, right? So we require support. The legislation doesn't legally recognize supporters. We only recognize here in Ontario substitutes meaning it's very black and white. It's either a person can make a decision or not, and if they can't, then somebody steps in and makes that decision for them. Okay? So, on the property side of things, if a person is deemed incapable, these are the only individuals that can step in to make a decision for them. First one's a guardian, and a guardian can only be appointed by the court or through the public guardian and trustee's office. If not a guardian, then if the person's capable of granting a power of attorney for property and has done so, it's the individual or the individuals identified in that document. And if not, the decision-making authority resorts to the Ontario Public Guardian and Trustee's Office.
So guardianship is always sort of given to a person, not necessarily an agency or...
Guardianship can only be granted by the court, first of all. So it's a very sort of comprehensive, costly, time-consuming process. There is a way for guardianship of property to be granted through the Public Guardian and Trustee's Office as well, but I sort of never recommend going that route. Typically it's a person, right, or the Public Guardian and Trustee that becomes guardian. You would, or should, never really see an agency step in to fulfill the role of the guardian, especially when the agency is providing service to the individual.
Okay, that's good to know, thanks.
On the personal care side of things, or this specifically deals with healthcare and making decisions regarding healthcare and admissions to long-term care facilities as well as personal assistance services, you can see that the hierarchy is a little bit more comprehensive. We've got guardian up here again. We've got attorney by way of a power of attorney for personal care. We've got a representative appointed by the Consent and Capacity Board, and I may touch on that later. But after those three, we've got family members on the list. Right, so the law says if a healthcare practitioner assesses me and doesn't think I'm capable of making a decision with regards to my treatment, then without a guardian, attorney, or for personal care or the CCB appointment, my spouse or common law partner can step in and make that decision. If I'm not married or I don't have a partner, then my child or my parent can step in and make that decision, if not my sibling and if not any other relative. So this is without any paperwork in place. This is just the way the law functions. We get a lot of calls from families saying, my son or my daughter's turning 18, or I've been told by somebody I've got to go out and get POA, or I've got to get guardianship, or whatever it is. And, this is sort of the point in the presentation where I say, guardianship is, and we'll talk a bit more about it in a few minutes, but it's really something that we don't encourage in the majority of situations. In the majority of situations, from a human right, well, on all situations, from a human rights standpoint, what you're saying is you're taking away the rights of a person, and you're giving those rights to somebody else. But from a practical standpoint, not only does it cost a lot of money, we tell people to budget about $10,000, and take a lot of time, but in a lot of situations, it's just simply not needed. Right, on the healthcare side of things, if you're a family member, you're kind of covered. Right, you can have input if the person cannot, or is deemed to be incapable of making their own decisions. On the property side of things, you may run into some issues, but if the person's sole source of income is ODSP, an ODSP representative can be appointed without any guardianship or power of attorney paperwork. And if their sole asset is the RDSP, a parent, spouse, or common law partner can be the plan holder of that RDSP without any paperwork in place as well.
Is someone ever going to suggest that you have to get one of these higher things than the parent or spouse or whatever? Like medical decision, they're going, well, we need a guardian and you need to, find a guardian, or, you know what I mean? Like,
they may, but that would
or
be...
Or they just say, well, we don't have that, we don't have that, we don't have that, so now you get to make the decision.
If they understand the law, then this is legislative. This is the way the law works. So they may request a power of attorney document or a guardianship order, but hopefully, after sessions like this, you're empowered with the knowledge now to say, well, you don't need that.
Yeah.
Right, I'm on this list as a parent.
Okay.
In terms of the legal instruments that we have available here in Ontario, We've got, so I've talked about, I mentioned that, you saw in that hierarchy that we have powers of attorney. So there are two types of powers of attorney. One dealing with your property and one dealing with your personal care. Okay, the continuing power of attorney for property allows somebody to make a decision on your behalf while you are still alive with matters related to your property. So it can become effective upon signing. Like upon signing, if I appoint my spouse as my attorney, she can go off and do whatever she'd like with my supposed fortune, right? Sell my house before I get back home and everything else. Or I can put a trigger provision in there that says it only becomes effective if I myself become incapable. I've got to be at least 18 to give this, and whoever I appoint has to be 18 as well. Okay? The issues that we run into with powers of attorney for property, though, is that the bar is pretty high when it comes to the capacity requirements that need to be met in order to give power of attorney. So in order to give a power of attorney for property, I've got to understand the kind and the value of my property. I must be aware of any obligations to dependents. I must know that and understand the authority of the attorney. Must know that the attorney must account for all of the transactions. Must understand that I can revoke this appointment. Must understand that my assets may decline. Must understand that the attorney may misuse his or her authority as well. So this involves a sound understanding of assets and liabilities and expenses and income and everything else. And so the bar is quite high. And because of that, when we look at completing powers of attorney documents for individuals in the sector, there are unfortunately many individuals that just simply won't meet this threshold, and therefore powers of attorney aren't available to them. Right? That choice is taken away from them in terms of who they want to appoint to support them. Okay. With respect to the power of attorney for personal care, so this is a document that applies to all aspects of your personal care, so your healthcare, hygiene, nutrition, safety, shelter, and clothing. It authorizes somebody to act only when you cannot act yourself. And you've got to be at least 16 years of age to grant, to give one, and whoever you appoint's got to be at least 16 years of age as well. Now the test for giving one of these is much lower. Okay, the person needs to understand that you care about them, and the person needs to understand that in some situations, if they can't act for themselves, or provide consent to themselves, you're going to have to do that. If that's the case, they meet the legal threshold, the legal requirements for granting a power of attorney for personal care. So we usually end up doing a lot more powers of attorney for personal care than we do powers of attorney for property. Because we can find that it's easier for individuals to meet this task rather than the capacity requirements associated with the power of attorney for property.
So who's making that decision on whether they think they understand?
Typically it's the lawyer if they go to a lawyer to do this document. They don't have to go to a lawyer.
Yeah.
But typically, if they do go to a lawyer, it's a lawyer that's determining whether or not the capacity is there.
And what happens if your child needs help with banking and stuff like that? They don't really have any money, but you've probably, like, I've got a bank account with my son, right? But like I'm the main, like
Right.
I can't do it without me signing.
Right, and that's a kind of a great way of providing support to him. So you may have a joint bank account with him,
Yes.
and you may have a good relationship with the bank, and the way that the account is set up, you may be able to provide support to him that way as a joint account holder.
What would be the best way to set up that account? That you just support him, like?
Yeah, it's not a bad way. A joint account isn't bad. Banks offer something called informal trust accounts as well, where you're kind of an informal trustee on the account, and the funds are there to benefit your son, which is another way of supporting him. Yeah. Yeah.
To go back to the power of attorney for property, you said it's not really necessary to have on your property?
Well, not in every situation. I'm just saying in a lot of a lot of families that we meet, their son or their daughter, the sole source of income may be ODSP, and you don't need a power of attorney for that. And the main asset may only be an RDSP, and as a parent, you don't need a power of attorney for that. So I'm not saying that this is the case in every single situation, but in many of the situations that we deal with, that those are the main income sources and assets that the individual has. And therefore, a power of attorney doesn't really provide them with any additional, I mean, it doesn't really give them much more.
Okay. My son is a young adult, and he has our ODSP and RDSP, but he also works. So I'm not concerned with the work, but I had problems with his RDSP, and they wouldn't talk to me because he's a young adult. And I said, well, I thought I had a power of attorney for him for the property, and I don't. It's personal care. So I'm thinking that I had to go get one for a property. But necessarily, I really ended up not having to, because then there was a government form that my son could sign. And I had to explain to him why he was signing it. So I could have the authority to talk to the bank in regards to his RDSP. But I should have probably had a power of attorney.
Well, you can't get a power of attorney for somebody else, right? Somebody has to give you power of attorney.
Yeah, my son, like we would go to the lawyer, my son would give me power of attorney on his
Because
thing.
he meets those capacity requirements for granting power of attorney.
Maybe half.
Yeah, so that's the issue that we run into, right? Now with the RDSP, the way the RDSP should have been set up, if your son required support, would have been with you as the plan holder.
And I am. But there was a whole bunch of other things involved, and I couldn't, because government was involved with it too, and they wouldn't talk to me in regards to, he was cut off on disability tax credit.
Okay, that's different though.
Okay.
Yeah.
But it all involved.
It all involved, yeah, okay. So CRA would have talked to you, which they often don't, without, you know, pushing back a little bit. There's a government form called the T-1013 that he can sign. Technically, he's got to understand what he's signing, but I've heard CRA multiple times say, just put an X here and we'll talk to you. But with you as the plan holder on the power of attorney, you're the one responsible for managing that plan. So you're the one that the bank has to speak to when it comes to managing that plan.
So basically, short and sweet of it, we don't really need to have a power of attorney for property.
You may not. Some people
Okay.
may, but, you know.
Would you get that anyway, whether you need it or not? Like, maybe he doesn't have anything at the moment, but like, I even came across a situation with his income tax, and they're saying, oh, well, you know, you have to have a power of attorney for us to even talk to you. And I thought, well,
The CRA form will allow you to talk to them.
Yeah, there's a CRA form, but it's sort of similar to a power of attorney, right? So if your son can't understand the form, technically, it's not really an option. Anybody that can grant power of attorney should grant power of attorney. And everybody should have one in place. We should all have one in place if we're able to grant it. The issue is that for many people in our sector, in our community, they don't have that option available to them because of the rigid capacity tests that apply. And there being no other option, right? So that's the issue. The only other instrument, unfortunately, out there is guardianship. So remember on the hierarchy of substitute decision makers, guardianship sort of trumps power of attorney, right? Or a power of attorney document. Two kinds of guardianship, one dealing with property, one dealing with personal care. On the personal care side of things, only a court can appoint a guardian, okay, for personal care. On the property side, it's the court, or if it's a family member applying, the public guardian and trustee's office. Now, step one with a guardianship application is always a finding that the person is incapable of making their own decisions. Right? So what you're essentially saying with guardianship is this person's incapable, he's gone through or she's gone through a fairly comprehensive capacity assessment. They've now lost all of their rights to make any kind of decision, open up any kind of bank account, and we're giving those rights to somebody else. So it's not something that the courts take for granted, or shouldn't take for granted. It's a fairly involved process, and as I mentioned, outside of the human rights implications, it is also quite costly. Any questions on that? It's important to note that in our legislation, in our laws say that guardianship should not be appointed and a finding of incapacity should not happen if there's a less restrictive solution in place, right? So if the person is able to grant power of attorney, that's great. Arguably, if a person has a personal support network around them, and that personal support network provides support when it comes to legal decision making, arguably that may satisfy this provision in the law. We haven't seen it sort of legally recognized, but I think a strong case could be made for that. The point here is that guardianship should be considered the absolute last resort. Because once guardianship is applied, that person is no longer viewed in the eyes of the law as an equal citizen.
When is it good to have guardianship then?
I don't know if I could ever think of it good to have guardianship. I mean, there's situations where, unfortunately, because there aren't any other options, guardianship is the only way to go. We see them when there's a court settlement happening after an accident. There's a big payout, and one of the stipulations of the settlement agreement is that a court-appointed guardian a guardian be appointed by the courts. Or we see guardianship applications, or we can sort of justify them a little bit more if someone is being taken advantage of by another person, whether it's a family member or a friend, and guardianship is the only way to provide a safeguard to abuse or potential abuse. But
So it should never be viewed as a protection against vulnerability, leaving your home, maybe going into services or something like that.
What do you mean, like in terms of applying for guardianship so that a person?
I feel like I just want to say I'm not personally looking for guardianship for my son, but the circle that I'm in, some parents were looking at that as a solution, as when they no longer can be at home for whatever reason, does it protect their vulnerabilities to go into services?
Right. From a practical standpoint, in some situations it may, depending on who your service provider is and depending on the nature of your son or your daughter's disability, but it shouldn't, right? Like it should not be required.
Can it ever be reversed if it's put in place?
Courts can reverse a guardianship, sure. Guardianships can be time limited, they can be partial. It would be very difficult to do so, because if someone is found incapable and goes through a capacity assessment, and then a guardian is appointed, and their condition has not changed, right? I can't see the court removing a guardian without appointing somebody else, because the courts aren't very progressive in this area of law or in this line of thinking. They're going to say, oh, a person's incapable. How can a person roam around our streets without any kind of capacity and any kind of, right? And so, once you kind of go down that route, arguably you're stuck there, unless we see some significant legislative reform.
And who would they appoint as a guardian?
Whoever applies. So usually somebody's applying to be a guardian. So it's mom or dad, sister, brother, friend applying to be a guardian. Yeah. If nobody applies and they think the person needs a guardian, then ultimately it would be the public guardian, be the government, the public guardian and trustee's office that steps up. And you really don't ever want to put a relative of yours in that situation where they're subjected to the public guardian and trustee's office acting as their guardian. Nothing against the public guardian and trustee's office, but why would you want a government entity now being responsible for every single decision that needs to be made? Okay. So issues and some responses. So we see that we've got a substitute decision-making legislative framework here. Either you can make a decision or you can't, and if you can't, your rights are taken away and they're given to somebody else, versus a supported decision-making approach, which we're going to talk a little bit more about in a few minutes. A person must be found incapable in order to receive any kind of support. All decision-making rights are taken away from somebody if they undergo a guardianship process. The requirements for granting power of attorney are quite high, thereby, removing that as an option for many people. This less restrictive requirement that I mentioned, the last resort requirement, isn't often probed in practice. The UN Convention, which I'll talk about in a few minutes, doesn't play a huge role. And so there's sort of two trains of thought. Some people will say, well, we just want to see the guardianship process made easier, more cost-effective, more timely. And there are others that say, well, wait a second, we don't even want to entertain guardianship because there are all of these human rights implications, and there should be other options out there that respect the rights of individuals to have a supported decision-making agreement in place. As a lawyer, we often find that families are incredibly confused when it comes to this area of the law because they're being told different things by different people, and all sorts of terms are thrown out, right? Guardian and power of attorney and subject decision maker, and people tend to use those terms interchangeably and without really understanding what each of them mean. You're being told by schools and government agencies and financial institutions and doctors that guardianship is required, right? And so you're sort of predisposed to that and really do think that it is necessary. When people come into our office, we generally dissuade them from going that route unless they really, really need, for whatever reason, to do so. We're dealing with a case right now where mom has died, dad's been out of the picture for a while, abused both of his kids. One has Down syndrome. His sister is his sort of knight in shining armor in terms of a supporter. But dad is still around somewhere in the background, and it's taken money from him in the past and everything else. And the only thing that she can think of doing in terms of protecting him is applying for guardianship, right? In those situations, it's very hard for us, even as opposed to, as we are the guardianship, to come up with any other solution, because our laws don't offer any other solutions. He can't grant power of attorney because of the legislative thresholds, and so sometimes we're forced to pursue something like that. But generally speaking, after speaking with the family and after sort of walking through the individual's assets and their income and their needs and their capabilities, a decision is made that guardianship application is simply not required. We encourage everybody to have a POA who's capable of doing so, and we've spoken about that. We try to accommodate as much as we can. A communication barrier should never be an obstacle to determining whether or not somebody's able to make their own decision, right? So, we'll use interpreters, iPads, bliss boards, whatever it takes to elicit that level of understanding and appreciation. On the property side, often trusts are used to decrease the potential for guardianship being required. With trusts, you can appoint trustees to administer funds and to act as supporters for the individual. We try to offer training to as many people as we possibly can, especially third parties, governments and schools and service providers and doctors, so that they understand consent capacity law and the implications of it. And we promote the development of personal support networks. We really do, because and Marty kind of made a good point in the last presentation. if you just assume that supported decision-making is the law, and you form this personal support network and you start operating that way, you'd be surprised as to how far that may take you, even within the current legislative context, right? But more than that, it will put more and more pressure, I think, on the decision makers, not decision makers, but on the authorities, on the government to have a look at our laws and to reform them in a way that's a little bit more progressive. Okay. That's my very quick overview of the way that the law kind of works here in Ontario. I usually spend a couple of hours on it, so I just want to make sure that everybody sort of understands the concepts that I've walked through so far before changing gears and getting into supported decision making. Any questions at all? Yeah.
Can I ask you a question? If let's say I have a son, and let's say his father's not really in his life, but like, you know, if something happened to me and there was money involved, his dad might come back into his life or something like that. Would the Henderson Trust, would that protect my son? It's like if I had my money put in the Henderson Trust?
The Henson Trust, the Henson Trust, you can set up you can appoint people to administer money that you set up in a trust. So that money's protected, but everything else wouldn't be, right? So money that you leave behind, and if you set it up in a proper type of trust and you appoint trustees, then that money can be administered by the people that you appoint. But let's say anything that's within his name, right? Like his RDSP, for example. His father would have, let's say, control over that, or could have control over that, or if your son then passed away without a will, then his father would inherit the money, his money, and that sort of thing.
So then to protect him, I should be making up his will so that the money goes to his sister?
If he's able to give a will. Because that level of understanding and appreciation has to be there. Yeah. Yeah, so it's a good idea. Just as it is for anybody to have a power of attorney in place who's able to do so, everybody should have a will in place who's able to do so.
So then, and it would probably do good for my daughter to be on the power of attorney too? Because at least I could trust her to look after her brother.
Yeah, so
like safeguard him against some certain things.
Again, you also have to think of it from your son's standpoint, right? So who would he want to authorize? Because it's got to come from him. So when we meet with anybody in our office, whether it's regardless again of ability, we try as much as we can to speak with the person one-on-one or alone, unless communication or interpretation is required, or right. So the direction has to come, let's say, from your son, and that level of understanding and appreciation has to be there as well.
And if he doesn't have that understanding to be able to do the power of attorney?
And unfortunately, the power of attorney isn't.
Yeah, then he won't be able to do a will. I don't feel that he would be able to in that situation.
So then how does that, like, my son doesn't see his dad as a threat, right? But he could be down the path when, money's involved, right? So, like, how do I protect him?
And unfortunately, given the laws that we have in place right now, which is why the laws are in need of such dire reform, the only way in that circumstance, if his father is a credible threat, would be for somebody to apply to become his guardian. But it would be, even in that case, it would be difficult probably for the guardianship order to be approved, because his father would have to be served with the guardianship papers and would have the opportunity to oppose it. Right? Yeah. So I think what you do, as much as you possibly can, is you protect any assets that you're leaving for your son in a trust.
And that would be the Henderson Trust.
There are all sorts of different types of trusts, right?
Okay.
But a Henson Trust would be one type of trust.
Okay.
Because you can control who the trustees of that trust are, right? And then nobody else can touch that money except for the trustees. And that money has to be there the only, if it's set up properly, the only person that can benefit from that money would be your son. And then you could actually say, if your son passes away and there's still money left in the trust, your will would dictate where the money goes.
Oh, okay.
Yeah.
Okay, yeah. So that would be a way around it, yeah.
But in her situation that she's chatting about, the father could come back and take whatever he wants out of the ODSP money.
Not necessarily.
No?
I mean, if ODSP is very, one sort of positive aspect of ODSP is that they're usually, didn't mean it that way, but they, usually they are, if the individual raises concern as to their ODSP representative or their ODSP trustee, typically the office will listen to that. Or if somebody else raises a concern, like people retain us all the time when ODSP trustee is taking advantage of the individual. We write a letter to the ODSP office, we express our concern, and they're usually fairly responsive in terms of removing that person. Now, once the individual receives their money, you need to set up the account in such a way that, dad may not be able to access those funds. So maybe the account is joint with somebody else, or it's one of these informal trust accounts.
Yeah, it's just really hard because, he's kind of in the background now, and my son loves them, but he doesn't understand the whole ramification
Sure.
of what his dad's all about.
Sure.
So I'm trying to protect him in that way.
So you can definitely set up the finances, pretty much everything short of the RDSP, in such a way where guardianship isn't required and where the money is protected.
That makes sense.
Any other questions? Okay. So we've identified the issues and the concerns that we have with the way the law currently, the law currently operates. And so what we want to really sort of start a conversation about tonight is how do we change the law? How do we change the law in a way that respects the rights of individuals and preserves their rights before the law, that enhances their ability to make their own decisions, while at the same time having the proper safeguards and protections in place. Okay? The way that we the way that the United Nations defines legal capacity, so is the capacity and the power to create, modify, or extinguish legal relationships. Okay, so signing contracts, managing property, etc. We then think about, okay, what kind of decisions matter to us? And it could be any decision related to healthcare, or where I want to live, what I want to eat, what I want to wear, where do I want to open a bank account, who do I want to hang out with, what do I want to do on the weekend, which hockey teams do I want to support, right? I mean, there's so many different types of decisions, and many of which we want to try our best to preserve in terms of allowing individuals the choice, the ability, and the autonomy to make their own decisions. But the problem with our law is that it requires some professionals in courts to make a finding of incapacity and to take away the rights of individuals because of that label in order to get any kind of support. Right, so if a person is sort of deemed incapable, in order for me to step in and provide that person with any kind of legal support, it often requires this label attached to them of incapacity. And so, what the law says right now, there's a word that's in a different spot here, but legal capacity, the law equates legal capacity, so the ability to enter into these legal relationships, with mental capacity, right? And they kind of equate one with the other, and that's something that we want to push in terms of changing. What is mental capacity? So on his or her own or independently, an individual can understand information, retain that information, appreciate the consequences, and communicate their decisions to somebody else. So it really reflects the basic tenets of what our legislation says in terms of assessing whether or not somebody has capacity, the ability to understand and appreciate and retain and communicate, etc. So we're saying in order to make any kind of decision, to have any kind of legal capacity, you must meet this requisite level of mental capacity, which is problematic. So this is just a cartoon that kind of illustrates this this point. So it says, come along now, one more label and you're ready to face the world. And we've got nutter and brave and burden and tragic and pathetic and less able and failure. And then we've got everybody lining up to the Department of Dependency and Care. Marty mentioned that a few years ago, Canada ratified what's called the UN Convention on the Rights of Persons with Disabilities. That was back in 2010. One of the articles of that convention is Article 12, which unfortunately Canada has sort of, for lack of a better phrase, opted out of, or said that they don't have to comply with. But what Article 12 says is that we have the right to make our own decisions. So we have the right to act autonomously. We've got that right. Everybody has that right, and that right shouldn't be taken away. Number two, states have an obligation to provide supports where needed to help somebody exercise their legal capacity. So inherently this means that there's an obligation on our government to implement some sort of supported decision-making framework. If a person requires supports, the UN Convention says that they should have those supports when it comes to legal decision-making. Three, whatever kind of legislative framework that we put in place should include safeguards. So we're not saying that fraudulent behavior isn't an issue or that safeguards aren't required. We do need to include safeguards and protections in the legislation, but from my standpoint, that shouldn't be the starting point, right? That should be a very, very strong consideration as part of the thought process. But if we decide to start at safeguards and protections, we'll never evolve, we'll never get anywhere. And four, the convention says that there is a duty to accommodate, okay? The duty to accommodate already exists in all of our human rights codes across the country, in every single province. It's not specific to decision-making. It's the duty to take proactive steps to ensure that services are provided without discrimination to individuals with disabilities. So what does this mean? It means that there's a duty on third-party providers, such as doctors and educators and lawyers and bankers, to ensure that that there are no barriers to accessibility when somebody is trying to exercise their rights with respect to legal decision-making and the accessibility of services. So what are some examples of accommodation? Okay? Examples of accommodation would include plain language material, okay, or extra time to process information, or really applicable to the purpose of this presentation, accepting the role of support people when it comes to making decisions about banking or medical care or education or whatever it is, whatever the subject matter is at hand. So this isn't by any means a novel concept. This is one of the tenets in our human rights legislation that's been around for many, many years, but for whatever reason, we don't apply it when it comes to legal decision-making. So we propose a new formula, okay? Article 12 says we need other ways to recognize and support the right to legal capacity. It should not just be based on a person's mental capacity. So here's a new formula. So we think about an individual's will and preferences. So that whole idea, we have all of these decision-making, all of these decisions that we need to make in life, and we want to really figure out a way that decision-making role can be exercised autonomously. Everyone's got unique decision-making abilities, meaning that we all require support. Some of us just require different levels of support. We add the supports that we put in place. We add the duty to accommodate, right? The plain language materials, the recognition of support workers, the extra time. And we recognize the fact that we now have this UN convention that says everyone is equal before the law, regardless of ability. Okay? And if we add all of those up and we put all of those together, it results in a determination that all of us are capable of making decisions. Okay, so we throw that legal capacity equals mental capacity equation out of the window, and we broaden it with these various components. In the new formula, as I mentioned, legal capacity doesn't equal mental capacity. What a person wants, their hopes, and their plans are at the center of every decision-making issue, not the parent's hopes and plans, or the siblings' hopes and plans, or the service provider hopes and plans, the individuals. The focus is on supports and accommodation. And when people have different ideas about what a person may want, they talk to figure out the best interpretation of the will and preference. They don't act in the best interest of somebody. We all tend to sort of gravitate towards thinking, well, what is best for the individual, right? What kind of, should the individual open an RDSP with their savings, or should they take that money and spend it on soft drinks and chips every day? I don't know, right? We would all lean towards saying, well, it makes a lot more sense to open up an RDSP and triple your money and everything else, but that's not really the mindset that we should be focused on. We should be focused on saying, okay, what does the individual want? Okay, and trying our best to facilitate that within reason, and with, there obviously are limits, and there are considerations that you want to think about in terms of the person's safety and security, and whether or not they're harming themselves or potentially harming others with decisions that they're making. But really, you want to start with trying to interpret what the individual's will and preference is, and trying to facilitate that as much as possible. Because we all have that freedom, right? The way that the law is defined right now, we're able to make poor decisions if we want to. Right? So again, in terms of the components, we're looking at expressing wills and preferences, really focusing on the I want to versus the no, really focusing on I want to or no, I don't want to versus what is best for you. Recognizing people you trust and you're already committed to, or relying on people that you trust and who are committed to you to help you interpret the world. So you'll see all sorts of language in supported decision-making laws that really speak to recognizing relationships of trust. Okay, so in other words, an individual walks into our office to execute a supported decision-making agreement. They may not meet all of those capacity requirements for granting a POA, but you can there is this relationship of trust that you observe and you witness, and through speaking with the individual and his mother, that you become aware of. And so we say, okay, we recognize that relationship of trust, and therefore that relationship of trust leads to mom being legally recognized as a supporter for this individual in assisting them with making decisions. And broadening that a little bit more beyond simply mom and dad and just parents, because I know a lot of parents are up at night thinking about, well, what happens when I'm not around? Sure, it's great if the law changes and I'm recognized as a supporter, but what happens after that, right? And so this is really where we get into the conversation around the development of a personal support network. Because ultimately what we'd like the law to evolve to is a point where personal support networks are recognized, right? People in a personal support network are recognized as the individual supporters, as Marty explained in Barb's situation. Barb had legal standing before the Human Rights Tribunal because the Human Rights Tribunal recognized the individual assisting her as her supporter. Barb was able to make this complaint with the support of her friend. And unfortunately, that is the exception right now rather than the norm.
I'm not sure if you're familiar with microboards, or I know microboards aren't that's not a term that's recognized
That's
in
trademarked in
Ontario,
BC,
but
so we
it's-
call it
right.
something else, but a self-directed support organization, yeah.
Right, so this, if you had that idea in mind, or your son or daughter had that idea in mind, that would really support this whole idea of supporting
Sure.
decision-making, right?
Absolutely.
Does it legally
Absolutely.
put something in place right now that's sort of that can be that decision-making body before the government catches up with us?
It's a more formalized, it's a legalized, so it provides legal structure to a personal support network, right? So all it is really are individuals that come together to support the individual and incorporate.
Which can include the individual, correct?
Which can include the
Yes.
individual. And they come together and they incorporate the whole sort of purpose of the organization is to provide support to the individual. Now, does that corporation have any kind of legal standing when it comes to supporting the individual and making a decision around where she wants to live, is the question. Arguably, based on a strict interpretation of the law, the answer is no, but it doesn't mean that it may not be possible. And it's-
So you could gain some momentum and say some smaller choices, say
absolutely.
around Wisdom Teeth or something like that, something that's,
Absolutely. Well, I tell the story of an individual who was in hospital in Essex County, and the individual had no family or friends, but had a personal support network and required treatment at the hospital. Couldn't make the decision themselves or herself, and the personal support network went to the doctors and said, this is what we think the individual would have wanted. And the doctors went to their board of ethics and explained the situation, and their board of ethics said, yeah, we will listen to the personal support network. We recognize this relationship of trust here, and we think that their intent is reflective of what the individual would have wanted, and it ended up being a legally binding decision. So your point around inertia and gathering momentum, I think, is very, very valid, right? And it will, I think, lead to, it will help in providing examples to, again, the decision makers, the legislatures, that, you know, this can actually work and hopefully lead to some sort of legislative reform. So we've walked through different types of accommodations and supports already. In Canada, you know, what we're talking about here tonight isn't novel. It isn't a novel concept, and it's not this, you know, sort of far-fetched ideology that you know, light years away from happening. This actually exists, and it exists here in Canada right now. I wouldn't say that there's any jurisdiction that has it completely right, but there are variations of supported decision-making already in British Columbia, Manitoba, Saskatchewan, and Alberta. Been in British Columbia going back to 2001. Right, so 13 years ago, they introduced something called the Representation Agreement Act, which is essentially a supported decision-making document that recognizes relationships of trust, allowing individuals in the person's life to support them with decisions associated with routine financial management.
is an organization called Plan sort of instrumental in getting that in place?
Plan's very involved with sort of, you know, more involved with the financial security side of things, but yeah, very familiar and very involved with the whole supported decision-making landscape as well. We do quite a bit of work with Plan out west. So the point here is that it can very easily happen here, and that, you know, arguably Ontario is somewhat behind in this specific area of law. You've got some jurisdictions that recognize sort of supported decision-making planning documents where the individual chooses and appoints supporters, or you also have other jurisdictions where they sort of coin the phrase co-decision-making, meaning that supporters are appointed by the court. So what then are we calling for here in Ontario? We want a recognition that supports or should be the norm for individuals when it comes to legal decision-making. We want prohibitions on findings of incapacity and substitute decision-making where alternatives exist. We want a legal obligation to explore alternatives. There needs to be the duty to accommodate by third parties needs to be enforced. It already exists in law. It just needs to be enforced. And we want this kind of legislative change obviously requires some government oversight. It requires some time, and therefore we need the government to make a commitment to allocate resources to make this a reality. So we really do want to change the paradigm from a presumption of capacity to a presumption to act independently. From capacity assessments to assessments for need and supports and alternative courses of action. From a finding of incapacity to a finding of needing support. From substitute decision-making to supported decision-making and the power to appoint. And from best interest to best interpretation of will and preference. Okay, so that's really the thrust of the mandate that we're looking to sort of propel. Here in Ontario right now, the Law Commission of Ontario has embarked on a project to look at laws related to legal decision-making and consent capacity, and it's sort of a multi-year project that both Gord Kyle, who's the Director of Social Affairs at Community Living Ontario, and myself sit on in terms of the advisory. So if anybody ever has any kind of feedback or comments or suggestions that they'd like to relay, please feel free to do that, and we'll do our best to communicate those ideas to the committee. So there is some hope that we may see change, maybe not in the immediate future, but sort of in the near future. But we'll sort of have to see. There is a platform for change. Let's put it that way, and the government is kind of taking submissions and listening to various stakeholders. We just have to hope that all of this feedback leads to a more progressive way of administering and supporting individuals to make their own decisions.
So my role is twofold. One is I work as an advocate for people with disabilities who often don't have family involved in their life, or people family that shouldn't be involved in their life.
Sure.
And so they're very interested in how to pursue this type of supportive directive. The other thing is that I'm a facilitator for People First, and this is something that they want to help kind of push along. What would be your best advice to how to direct us? Should we go into the Law Commission of Ontario? Should they be contacting their MPPs? Should they be having this discussion?
So there, if you send me an email, there is the Law Commission of Ontario is taking submissions. I think right into the spring, I believe. I'm not 100% sure, but I can have a look on ideas around reforming the legislation. This is a provincial issue, so this is within the jurisdiction of the provinces. So speaking to MPPs would be very, very helpful. The one suggestion I would make, though, is that when speaking to MPPs, you want to ensure that the message is clear and somewhat scripted, because what I've seen happen in too many situations is, the outcome of the conversation or the interpretation is that guardianship should be made easier and more accessible. And unfortunately, it's just, it is, and so the messaging is very, very important when speaking to politicians who may not be familiar with this area of the law.
So is there such a script, or can parents who really want to help move this forward, is there sort of contained information that we can get to before we go? Awesome.
Yeah, you've got this, but feel free to contact me. Perhaps
this isn't an elevator speech, though.
Yeah. Perhaps there's something that we're able to put together, maybe at at Community Living Ontario, or there's something that already
I'm
exists
just
that we may be able to
thinking across
circulate?
Ontario, this group of parents that sort of flooded the ombudsman's office, right?
Yeah.
With issues, and now it's a whole other realm, I think, of empowered family members and parents that could really maybe use a script to make sure the messaging is in
I
place.
agree with you 100%. And, you know, I think with the first round of complaints to the Ombudsman's office, it was you know, it was a fairly simple issue to understand, right? That there aren't enough supports out there, period. Financial supports
Right.
for services and supports. This is a little bit more complex. So you're going
Right.
to see the parent community splintered, right? You're going to see a lot of parents saying, I just want guardianship. Just make it easier for me,
Right.
quicker for me and less expensive. And then you're going to see others saying that I want to do something that I want to see change that actually respects the rights of my son or my daughter. So again, the messaging is very clear. The education piece is very, very important as well. Any other?
I was just
Questions?
gonna put a little piece in. I think, you know, with children with disabilities, I think it's pretty hard to, like my son, he understands everything when you tell him stuff and that, but he may not understand the ramifications of stuff. Like, you know, he's been living in hospital per se. So, you know, he doesn't realize that he could just walk out at any time, right?
Sure.
But if he did that, he doesn't understand, well, you know, I have no place to go, I have, you know, and he's vulnerable to society and what they will do to him because, you know, like he got away one time and he was even in protective, and he ended up in a dumpster. So like, you know, and like the police were called and he was taken back to the hospital and everything. So, you know, like his capacity of understanding the ramifications of what he wants, it may not be on the level of, you know, like he knows and trusts me and everything to do the right thing. But, you know, he may think that he's capable of doing it on his own, which he's not.
Sure.
Because he's vulnerable of the outside world, which he doesn't, you know, he thinks
Sure.
everybody's his friend and everything like that. So it's really hard to, like in some ways, you know, I get the guardianship thing, but at the same time, I want him to be able to speak for himself too, because he does understand. So, you know, part of me wants to go after guardianship, and part of me wants, I don't want him labeled, because, you know, he is, in many aspects, he's pretty intelligent.
So you require support, right? And I think that's what you're saying. You require support, and so there needs to be a way for that support to be recognized in our law.
Yeah. Yeah, I guess that's the main thing, that, you know, and you know, the hospital's been really good. They do help me with my, you know, they do realize that Brendon cannot do it by himself. They do realize that. So they have kind of labeled him, you know, in a certain way. But it's just, you know.
Yeah, there are very difficult situations that you know, one solution can't address absolutely everything, but I do think you're talking about a sort of a prime example of an individual that requires support, an individual that we don't want to label as incapable, but requires some safeguards, requires some protections, requires some supports, and what we need is a lot of change to recognize.
Well, he does need 24/7 care, because he just, you know, he's a person on his own, he just wouldn't be able to survive.
Sure.
Other questions, other comments?
Early on, you mentioned something about ODSP, and I wasn't understanding if you meant that they could take trusteeship if someone's current trustee was not.
No. Well, all I was saying with ODSP, the law allows for an ODSP representative to be appointed to help administer ODSP benefits only. So if that ODSP representative wasn't acting in the best interests of the individual, he or she could be removed and replaced. But we're talking about ODSP money only.
Right,
Yeah.
but it's not that the ODSP staff would do that job.
Well, somebody would have to bring it to their attention.
Right. Yes,
Yeah,
in my role, I often have to bring those kinds of things to
yeah,
their
and then the
attention.
ODSP staff could remove.
They can remove, but they never have anyone to replace it with.
Well, we're assuming that there is somebody to replace,
Yeah.
right? And if there's not, then arguably, unfortunately, if the person requires support, it may have to be the public guardian and trustee's office that's contacted.
So, as Brendon was saying, some of the things that we can do is act as if supported decision-making is in place. That we do recognize that people can be involved in the decisions about their lives. They tell us with their actions and with their words and deeds. And years ago, compliance was a big word in our field. That people had to be compliant and that they were going to follow the schedule. And the schedule said laundry is Tuesday night. And, whether the person wanted to do their laundry. And that's why our staff used to get bopped a lot. People rebelled from others making those small decisions, but important decisions, because maybe the person wanted to watch the hockey game that night instead. So I think we've seen a lot of growth and evolution over the years. Barb, you're a pioneer. You were recognized by the Human Rights Tribunal that you had the right to put in your complaint with supports. And so that was a precedent-setting case in Ontario. So we appreciate what you've done for people, Barb, and it's very important. You got to meet a few lawyers along the way.
Can I ask you something, Bonnie?
Yep.
People are making fun of people. I will stick up for them.
Yes, you have. And we appreciate the fact that you have done that on behalf of a lot of other people. You stood up for them.
When people can't talk over the things, computers.
Mm-hmm. So we do thank you for what you did in taking your complaint upward. So thank you very much, and we're very proud of you. And Brendon, we appreciate you coming. This is your second time, I think?
Second time, Silverberg, yeah.
And again, I think we want to try to make this an annual discussion, because each year we want to see more progress made that allows people to be making the decisions that are important in their lives. And yes, they need support to
Absolutely.
make that, and there's got to be safeguards.
There's got to be safeguards, and we're not suggesting that safeguards should be ignored, but it shouldn't be the focal point of our thinking.
So we appreciate you spending the time with us.
Thank you, buddy. Thanks for having me.
We do have a bit of time to
Yeah, absolutely.
take a few personal questions
Absolutely.
if anybody has.